good afternoon, good morning, good afternoon, and good evening. My name is Kyung-Hwa Chung, and I'm an off-counsel at Covington & Bowling. Welcome to today's webinar hosted by the KCAB Next. KCAB Next is an organization for arbitration practitioners under the auspices of the KCAB International. We host webinars, mentoring program, and networking sessions throughout the year. So stay tuned. Today, we have a very interesting topic to discuss with panelists from all around the world. Is international arbitration uniform worldwide? Do we still observe differences arising from the influence of civil and common law jurisdictions? How is international arbitration conducted differently in other parts of the world? We will hear from distinguished panelists, Semi Kim, Zia Dubey, J. Patrick Santiago, and Omar Pertas. Semi is a partner at Lee & Co. in Korea. Semi is admitted to Korean bar and admission to the California bar is pending. She represents clients in arbitration, pre-arbitration and enforcement proceedings of various cross-border disputes related to M&A, life sciences, telecommunications, shipping, and construction matters. Zia is a managing partner at Obeid & Partners. He's a dual qualified lawyer with a civil engineering background and has extensive cross-border experience from his legal practice in Europe and the Middle East. Zia has specific sector-focused experience advising corporations in relation to large, complex civil engineering, industrial, including nuclear, infrastructure, and energy projects. Zia also sits frequently as an arbitrator. J. Patrick Santiago is a Philippine qualified attorney, England and Wales solicitor, and an arbitrator based in the Philippines with extensive experience in international arbitration in Hong Kong, Singapore, and the Philippines as arbitrator, counsel, and tribal secretary. He's a trustee and a senior VP of the Philippine Institute of Arbitrators. Last but not least, Omar is a partner at Cuatro Casas, specializing in international arbitration, global disputes, and crisis management. Omar is now based in Barcelona, but has worked in New York and was the managing partner of the firm's Shanghai office for more than a decade, advising Asian, European, and Latin American clients. I'll be co-moderating the session with my colleague Inha Kwan, a senior counsel at Hyundai Heavy Industries Group. We are really international today. Inha is joining from Vienna in Austria. Omar is in Barcelona, Spain. Jay in Manila. Ziad is are you in Beirut, I believe? And Semi in Korea, and myself in New York. So first, without further ado, let's start with the written phase of proceedings. Within common law jurisdictions, a party commences a case with a brief statement or an outline of a claim, which is fully developed in the course of discovery. By contrast, in civil law jurisdictions, we see a front-loading approach. That is including full factual background, the laws on which the claim is founded, and other relevant documents and authorities in a statement of claim. These different approaches are somewhat reflected in the written phase of international arbitration, the so-called memorial approach and pleadings approach. Memorial approach refers to filing of a document which includes a party's position on facts and law, together with not only documentary evidence, but also witness statements and expert reports. There is some variation in pleadings approach across common law jurisdictions, but generally speaking, the written phase is split into several phases. First, filing a document which includes facts and legal arguments with documentary evidence. And second, filing of witness statements and expert reports. Now, I would like to propose a question to the panelists. So what is the practice in your region? Do you see both approaches being taken, or do you see a strong preference for a particular style? If there is any strong preference for a certain style, what is the reason behind? And what are some of the factors to consider in deciding which approach to adopt? Shall we start with Semi?
Hi, everyone. Thank you for the kind introduction, Kyunghwa. And I would like to thank KCAB Next for holding this interesting webinar today. To answer your question, I guess you gave a very detailed and well explanation about what, memorial style is and pleading style is. And I guess the arbitration cases, they're all different depending on who your arbitrator is. But most of the cases that I've worked on adopted the memorial style. And as I asked around my colleagues in the arbitration community here, I think there is a strong preference for memorial style among Korean practitioners. I assume that it's because the memorial style itself derives from the court practice of civil law jurisdictions, where we usually include all the legal exhibits, factual exhibits, and witness statements all together with the submissions. And another practical reason for this strong preference could be because memorial style ensures that the tribunal gets a clear, like a complete picture of the case relatively early in the proceeding. Recently, I had a few cases on pleading style where you submit the witness statement later after the written submissions have been exchanged. And it was nice to know each party's argument before preparing the witness statements, but I realized that sometimes your narrative of your case, like the story, the underlying story of your argument would change after talking to the witness. And around that time when you're preparing the witness statement, the written pleadings previously submitted would be forgotten. And it felt like, although we already had each party's arguments on paper, we ended up submitting various witness statements rebutting all the factual allegations newly introduced in their witness statements, and we ended up submitting more witness statements than what you would usually do in memorial style. So it felt like there was just another version of the written submission round, just with detailed facts, and which were not combined with legal exhibits and legal arguments. So when we went to the hearing, we collected all the written submissions, all the factual exhibits, legal exhibits, and the witness statements, and we prepared the opening presentation slide based on all those informations. And what the tribunal said to the both parties, it was like, well, thank you for a helpful opening statement, but I don't think you've given a complete picture of the case. And I thought it was a natural response from the tribunal because they've never read a complete submission, written submission with all the legal exhibits or all the factual arguments and all the witness statements all combined together. So of course, by the end of the hearing, he had a clear picture of the case and everything went well. But I just felt like memorial style would be better. It better supports the effective management of the case. Of course, some cases would not be suitable for memorial case, especially if your case is based on an old contract where you don't have the employees who worked on that contract anymore, or if you don't have any documentary evidence and you have to go through all the digging all the evidence. But I guess for most of the cases, I think memorial style would serve better the party's interest.
Just out of curiosity, if you don't mind asking a question,
Mhm.
why was pleading style chosen for that particular case, if you remember? If the tribunal is unhappy eventually.
Well, it was kind of based on the common law approach. So the counsels, we were co-counsel with another law firm in Singapore, and the other side was also a Singapore firm. And I think like the Singapore practice is more close to the pleading style approach. So I guess that was the start of the style. Yeah.
Because of the time, shall we move to Jay? Jay, would you like to share your experience?
Sure. I guess at the outset, I wish to highlight that the Philippines is actually a mix of common law and civil law jurisdiction, such that when I worked in Hong Kong and also got to work with counsels from outside the Philippines, and we were talking about common law and civil law jurisdiction, I was actually confused because in law school I was taught that Philippines is predominantly a civil law jurisdiction, but then what I heard to be the practices in common law jurisdiction is actually very similar to the practices that we have in the Philippines. And so I was like, I think based on my experience in international arbitration, where there is a mix of common law and civil law, the practice in the Philippines is already very similar to what is being done in international arbitration. So I guess that answers the question in the Philippines. I mean, is it common law or civil law? I say it's a mix. What do the parties or the counsels usually do? I think from my experience, it's also a mix. It's also a mix. If there are counsels that are, I think in the first place, you need to look at the rules. If the rules provide for what is needed in order to commence an arbitration, then you just need to put it there. What is required. And usually from my experience, they use the pleading style. They just want to put out there the bare minimum of what the claim is all about. And then later on, parties will be given an opportunity to submit a statement of claim, and then later on the witness statements and so on and so forth. I think there is a preference from the jurisdictions I have practiced to use the pleadings approach. Only because I think they want to make sure that this initial submission, is not going to prejudice any of their future actions, such that if you already mentioned something, you're not going to change it, later on, right? You want to make sure that your case progresses as the case, your pleadings progress as the case also progresses. I think there is some advantage in the memorial approach. I think if you want to already put everything there and want to have a discussion, probably a negotiation outside of the arbitration with the other party, to really show that, hey, this is the case, this is what the case is all about. We now know everything. We put on the table everything that we know about the case. And now that everyone knows what the other side wishes to present, we can now sit down and have a discussion on how we can settle this particular case. On the other hand, I think pleadings approach is also more cost efficient, because you don't have to pay your lawyers that much yet in the initial stages or in the preparation of pleadings, if you at the end of the day really want to settle. And in any event, you can submit any of these additional information or the documents that you need not present to the arbitrators, but you can present during the negotiation with the other party, and therefore saving the client a lot of costs.
Thanks, Jay. Shall we move on to Omar? Could you share your experience in Europe and other parts of the world?
That was for me, right, Kyunghwa?
Yes.
Yeah. So thanks a lot, Kyunghwa, first for organizing and for KCAB Next for the organization. Thanks a lot, and happy to be here with you guys. Well, in Spain, if we look into judicial proceedings, basically are structured as follows. You will file a lawsuit. The defendant will submit a response. There will be a preliminary hearing on procedural matters, basically, and a hearing. There is therefore no discovery phase, and accordingly, the claimant will present its case as fully as possible from the outset. As for international arbitration, in my practice in this region, I would say that basically we have a memorial approach where basically in the statement of claim, you will present fully your case together with the witness statements. There may be cases where, for strategic reasons, you don't want to do that. And we have seen cases of that quite recently, to be honest. But most of the times it will be a memorial approach. What I would like also to discuss with you is something that is a little bit worrying to me, is this exceptional flexibility that international arbitration shows more and more, where basically everything goes and everything will be admitted by the tribunal at any stage of the proceeding, right? So no matter what the parties will submit at any time, whatever, even if new legal arguments at any time, the tribunal will say, well, it's fine, right? So, and I see that especially so when we have English law applicable to the merits, and also when we have English lawyers as opposing counsel, where I have seen where we will have new legal arguments basically at any stage of the proceedings. So that to me is a bit disconcerting, and I just wanted to share that with you. But basically, that's my experience. Yeah.
Thanks much, Omar. Zia, let's go to Middle East.
Thank you. Thank you. Let me first say that it's a great pleasure to be with you this afternoon, your time. It's morning my time. I'm in Paris today, but I'll be covering the Middle East from my practice in the region. Thank you also, Kyunghwa, and for the KCAB for inviting me, and also for all your efforts in putting together this wonderful event. Let me first start by saying that some consider that the clash of memorials and pleadings is essentially a cultural one. And it has certainly been a topic of intense debate in the international arbitration sector. Now, we've heard from Saimi, Jay, and Omar, and I agree with the experiences that they've shared with us. Certainly, from my perspective, in the Middle East, there is a preference for tribunals to get a complete package of the legal and factual matters from the very start of the arbitration, and that's really a reflection of the fact that most systems in the region, from the Gulf to the broader Middle East, are inherently civil law systems. And the tradition is therefore that you would sort of have your old cards on the table. You bring your big ships to the front, and that the process of arbitration intends to show the entirety of the case to the tribunal from the outset. Of course, in the region as well, we know that we have what we call common law islands within a broader civil law framework. And it very much depends on who your counsel are, your tribunal, and certainly sometimes strategies, whether you're a claimant or you're a respondent, there are considerations of time and cost. And in other instances, it's the type of case, whether it's a construction case that would warrant a different approach, and the tribunal would be open to considering that. Certainly, from as I said, my preference generally is for a memorials approach. At least that's what I've seen in many cases in the region. Although one needs to keep an open mind about tailoring the case to the specific needs of a particular dispute. I agree with Jay as well and Saimi when they expressed the view that memorial have the effect of encouraging parties really to face up the case from a very early stage. And that certainly reminds them of the extra expense that they will have to expand in the early stages of the arbitrations. Often those legal and commercial influence could encourage parties to engage in realistic early evaluations of the disputes and potentially early settlement. From my approach as an arbitrator as well, I think we've seen sometimes how in certain instances a pleadings approach can lead to procedural issues and procedural difficulties. As Saibi said, sometimes counsel, and it's realistic, they discover when they're preparing, working with witnesses and experts, so on and so forth, that the case is taking a different directions, and we sort of start having a series of procedural issues that could have been avoided had the case been more streamlined and concentrated at the beginning. Because I'm concluding on this topic, maybe I could suggest an alternative. There's maybe a third alternative. We're discussing memorials and pleadings. And I think, why are we having that discussion? Certainly, I think from my perspective, the objective is to see how we can enhance the resolution of disputes early on and how we can overall improve arbitrations. And I think, if I may start from an observation, is that today one of the problems that we have is that tribunals and council, they sort of gravitate towards a standardized one-size-fits-all approach when they seek to send the entire proceedings at the beginning of the case, before they're really in possession of a detailed knowledge of the matter. And the problem is that this tends to result in the longer and costlier proceedings, and typically it defers the early or any substantive engagement by the tribunal until really the merits hearing at the end of the case. And when sometimes it's too late for the parties to tailor their submissions to the tribunal's particular questions and concerns. So some practitioners in the international arbitration arena, and specifically also, I could mention Constantine Partisitis and Scott Vessel, they raised an idea a few years ago, which was interesting, about looking at the arbitration as if it were comprising two acts. And then you start with a first act where the parties would expose the facts and the parties' positions will be set out in their first substantive submissions. The beginning of that act would be the CMC that we know, the Case Management Conference. But at the end of the first exchange of submission, Act 2 will start. And that's where, before proceeding with the second round of submissions, instead of having a CMC, we'll have a CRC, which is a Case Review Conference. And that would allow early substantive engagement on the merits by the tribunal, that would have seen the pleadings exchange, the first set of pleadings, and then they would be able to discuss how the remaining phases of the arbitration can be streamlined based on the early engagements about the issues, whether certain things can be determined or certain things have been missed. So that's potentially a hybrid approach, a mix between memorial and pleadings approach, and a third way to consider.
Thank you so much for the interesting suggestion, Ziad, and thank you all for your sharing your views about this. I know we can go on and on about discussing this, but let's move on to a different topic: document production, which really troubles me. Discovery and disclosure, the terms are differently used in other jurisdictions, but one of the most stark contrasts between civil and common law jurisdiction would be discovery. Under common law jurisdictions, parties are obliged to disclose documents relevant to the issues in dispute, regardless of whether or not they support your claim. In civil law jurisdictions, discovery is only permitted in limited circumstances. Inhwa, could you share the chart that I would like to discuss today? So in the chart that Inhwa will be uploading right now, this is an international arbitration survey conducted by Queen Mary University of London in 2021. You can see that, interestingly, 27% of the respondents answered that document production is one of procedural options that they would be willing to do without to make arbitration cheaper and faster. Respondents were asked to choose up to 3 in no order of preference from a list of procedural options that they would be willing to do without to cut cost and time. And as you see from the chart, document production ranked the 3rd. I would like to ask to the panelists whether they have any experience doing arbitration without document production. Is document production really indispensable to international arbitration? Let me sort of provoke, send this provoking question to the panelists. Jay, would you like to start?
Sure. Thank you for that question, for the introduction. I think document production is one of those stages in the arbitration that can be abused and can also be used as a matter of strategy, in deciding, in discussing matters with the other party. You can inundate the other party with requests for a lot of document production, which unfortunately will also make the arbitrators kind of not happy because they kind of know how things work. So it's a delicate balance. If you're going to use it as a tool to antagonize the other party, to make them do something during the negotiation phase, you got to you got to be really careful about that, because the arbitrators know what you're actually doing, and that can actually be used against you in the future. So I think, yes, it is possible for arbitration without, especially international arbitration, without document production. I have certainly had cases where that was not availed of by the parties, especially in cases where parties have already prepared very well prior to the commencement of the arbitration, and so they do have all the documents already, all the relevant documents, and will not get those documents only during the arbitration proceeding itself. I think one thing that dissuades parties from requesting a document production is that it is very easy to evade an order for document production. I've had cases before where we had to go to the courts to enforce an order for production because the party just really refuses to do it. And we even sought additional remedies against third parties in order to get the same document. But that kind of really just complicated the case. And a simple document production request from that single document production request came like 3 separate proceedings in court. So it can be really, really complicated. So if I were the counsel, I would really just request for document production if necessary, and if necessary, maybe as a tool for negotiations. But other than that, I would be very prepared prior to the commencement of the arbitration and make sure that I have all the documents already in place before I commence an arbitration.
Thanks, Jay. Omar, would you like to share your experience?
Yes, absolutely. Yeah, I would like to get rid of document production, to be honest. I think it is very easy to evade, as Jay was saying. It's very easy not to produce exactly what you are asking for. And even if they produce what you have asked for, there is no way to tell if they really produce everything that they have in their hands at so many times, right? I mean, this is the truth, right? I mean, this is what we face when we actually ask for things and we are thinking there should be more, but there is no way to, to prove it, right? Of course, because they haven't produced that, right? My trouble, as I share the trouble with Kyunghwa, probably comes from the first discovery I worked on when I was in New York, and I spent like 4 months in a room doing discovery work, redacting things. Now the computers do that, luckily, but at that time it was me for 4 months trying to figure out what is privilege, attorney-client, and all this stuff. So from that moment, I really, don't appreciate document production anymore. But speaking about Spain at the local level, just to give you a glimpse, the Spanish Arbitration Act does not foresee any document production or phase or discovery phase. So if you look at the Madrid International Arbitration Center, also do not provide discovery phase. They do provide the possibility for the parties to ask the other party to produce documents, but there is no as such document production phase. But to be honest, I have not participated in almost any international arbitration where there was not document production. We are drawn to that. For some reason, we have to ask, just in case they're shown, you will get something, and out of 100,000 documents, you may get one, right? Out of just because the other party just forgot to actually look into that one. So I think most of the times is a complete waste of time, to be honest. But yet again, it's always there, right? I have asked in the team, have you guys actually worked in a arbitration proceeding where you didn't have document production? And someone said yes, one, and it was great. It was great. It was so much faster, so much cheaper, but it was a small case. So basically, unfortunately, I would like to get rid of it, but there is no way to manage that yet. Yeah, thanks.
Thanks, Omar. I'm sure if we have like younger associates, they can go on and on, days and months, to complain about document production, because that's why they suffer during international arbitration, and that's why people, decide to leave, international arbitration. Zia, would you like to share your views on this?
Thank you.
I can go on and on about this because, I had so many nightmares doing document production and discovery, but I'll just, keep myself to this. And Zia, I'll give you the floor.
Thank you. Thank you. Well, just to continue the debate, perhaps I would say that I won't be as extreme as maybe, for example, the suggestions that Omar made, that we should get rid of document production. I agree that unfortunately this is a principle that has been abused to some extent, and the difficulty is that when a process is to some extent abused or becomes sort of used in a manner that defeats the purpose behind which it was first considered in international arbitration, then we start questioning the very existence of a tool that could be very beneficial in certain instances. So my experience is that it would be helpful, of course, to keep document production. I wouldn't get rid of it, but it has to be reconsidered in the sense that council should really take the time to think whether they really need to make 125 document requests every time in an arbitration and burden the tribunal with those. Document production can be very helpful, particularly because you have sometimes interrelated disputes and disputes in different contractual chains, subcontractor, main contractor disputes, and so on and so forth. And sometimes having a sort of transparency of correspondence is not always there, and having sort of the ability to ask for certain key and material documents could very much change the case in one direction to the other. And so I think it's important to have the document production, because in one sense, it would also keep the parties in check to make sure that they have pleaded cases that are consistent and certainly within the overall constraint of the at least in the Middle East, the civil law approach, where the style of advocacy is really overwhelmingly influenced in the Middle East by civil law traditions, and that is typically founded on the basic principle that there is no discovery and there are limited options for request of the production of documents. But of course, again, in the Middle East, this will also depend on the approach that council take. And of course, we have many common law trained and experienced counsel who would sort of, naturally they have a tendency for making document production requests. And I think the starting point start with first counsel curtailing those requests so that we can focus on what's essential. I had a case where acting as counsel for one of the parties, and then in the early exchange of documents between production requests between counsel, we found out that we had about, in total, more than 200 document production requests. And I had to sit down with my team and say, okay, realistically, if we put ourselves in the shoes of the tribunal, are we going to go through with those 200 requests and then give them the same attention that is needed? And then a number of those requests, do we really need them? And finally, at least from our team, we considered that all we needed was really 3 specific requests, no more than that. And then strategically, the case turned at the end when we decided to limit those requests to those 3 specific requests. That has certainly focused the attention of the tribunal on really the key issues that matter. And at the end, we got those requests, and that was really what we needed. So the question sometimes is really to spend time and consider how you want to tailor your case, and whether you really need to ask for all sets of documents in different formats and all categories of documents and so on and so forth. So that's it for me, briefly on the topic. Thank you.
Thanks much, Ziad. Semi, would you like to continue?
Yeah, same as Omar. I haven't had any cases without document production. Although in some cases the scope of the document production was had been limited. And when I asked around, the only cases where they didn't have document production was, like Omar mentioned, when the case was small or when the other side didn't participate. So, and instead of removing having a case without document production, I had one case where the parties decided to limit the number of requests that you could submit to the tribunal, to the other side and to the tribunal. So that was a helpful idea to utilize. And although I fully agree that unnecessary and lengthy document production should be avoided and it shouldn't be abused as dilatory tactics, I share Ziad's view that it will be difficult to totally remove the document production itself. I mean, the possibility is not that high, but it does provide the claimants and the respondent with the bullets to fight in the battle, and which they were not able to find at the first place. If they had all the documents, they would have just avoided starting the arbitration if they had like the documents itself. I see Ziad raised his hand, but just to wrap up my comment. So I guess it is important to manage the document production as concise and specific as possible. Thank you.
Ziad, would you like to limit your follow-up question or comment to a minute?
Just very briefly, I think it was interesting that the situation where one of the parties, say the respondent, is not participating in the use of document production. Actually, my experience is quite the opposite in that specifically, I mean, certainly when I'm acting as an arbitrator, when a party is not participating, it is very, very important to have document production sometimes, because to discharge his duty as an arbitrator and ensure that the award is enforceable, at some point, you have your statement of claim, and then you don't have any other submission. So the only way is really to tailor the process to have targeted questions, but specifically sometimes document production requests from the claimant to ensure that you just don't have a limited set of documents, or they could be simple issues. For example, I have this amount is outstanding, but and I'm claiming it. If you don't have a respondent party challenging it or accepting it, it'd be very difficult based on the document, unless you ask for additional documentation to establish sometimes simple facts. And I think it is very, very important in the context of default proceedings for tribunals, and at least to have at their disposal the ability to order the production of document. But in that case, it would be the tribunal driving the process and not the parties between them sort of exchanging documents.
Great, thank you so much, Ziad. From now on, Inha will lead the questions.
Right, thank you. For the sake of time, I would try to limit the general introduction as to what we'd like to talk about when I give a question. I will start with Omar for my first question regarding witness preparation. We are aware that different jurisdictions, attorneys' rule may allow or not, whether you could prepare a witness at all or to what extent. Could you briefly share your experience from your jurisdiction? What are the rules regarding the witness preparation and your experience internationally? So first, about your rules from your jurisdiction, perhaps, or the practice you've seen. And second, picking up on what Ziad was proposing earlier regarding our first question, that we would see a lot of standardized practice in international arbitration, I would also like to ask the panelists if you have seen such standardized practice with witness preparation as well, although you will be bound to, or each attorney will be bound to the individual attorney's rule from their license, but the team of lawyers from different parts of the world may affect the proceedings, the preparation. So I'm wondering what are the international standards that you've seen, or what are the ways we should seek in international arbitration to be the best practice? So two-pronged question, if you allow me. with Omar.
Okay,
First.
very good. Okay, thanks a lot. Locally, in Spain, in theory, witnesses should not be prepared before a trial. However, I would say lawyers always do, and tribunals know about it. So,
Are you allowed to
that's,
say it out loud in this webinar like this?
well, yes, I think so. That this is the truth. I mean, mostly, you know, that is what really happens. Then, in terms of international arbitration, according to our experience in basically every case that we have been involved, we have been allowed to meet with the witnesses prior to the hearing in order to mock examine them, right? We try to practice and predict the possible questions that the opposing party may ask, also advise them on how to address the hearing, how to not be overwhelmed in the cross-examination, what kind of things they can do if they really want to explain themselves, how to really be prepared for that. I would say that is not, you know, comfortable for most of the people to be cross-examined, especially when you have a very aggressive cross-examiner, as it happens often. So it is very important that you actually have the opportunity to prepare and to talk to the witness, so they know what is coming, right? Because at the end of the day, what you want is to explain the truth, and so many times they can't, right? They are constantly being interrupted. I mean, you get to a point where the whole thing becomes kill the witness in cross-examination, right? Recently, I was reading this article called "How to Kill the Witness in Cross-Examination." I was like, God, I mean, I understand the point, but I mean, the whole point was the truth in the first place, right? So, I mean, we have been always able to contact and to really work with the witnesses, and in my experience, and I would say this is a very common thing in our jurisdiction. We have, I asked the team again, and they told me that there have been some specific cases in which they were not allowed to talk with witnesses from the moment the hearing started until the cross-examination finished. But this seems to be rather the exception, to be honest. Yeah.
Just out of curiosity, what were the rules, or what was the attorney's rule bounding them to not speak with the witnesses at all?
I did not ask about this, but that seems to be that the rules
Sorry
they
for
get
all these
themselves
random
in the no, it's fine, in the proceeding. Yeah.
Right. I'm gonna turn to Ziad. Do you share Umar's view? And I'm curious if you see the witness preparation as a preparation of witness for the whole parties and the tribunal to find the truth in the proceedings. Just an add-on question on top of your experience about witness preparation in your jurisdiction and standardized practice, if you have seen, or if you can say that there is one.
Yes, no, thank you. Well, let me first, first to start generally, in the Middle East, again, the style of advocacy is really overwhelmingly influenced by civil law tradition. And the basic principle in relation to that is that there is primary reliance on documentary evidence and only secondary reliance on witness testimony. Why is that? Typically, certainly in the Middle East, potentially in other regions of the world where civil law systems are the predominant, there is some sort of skepticism toward witnesses, party-appointed experts, and cross-examination techniques. I mean, in court procedures, you have a court-appointed expert. You don't necessarily have a party-appointed expert. And there are specific rules even before local procedures about who can be a witness and who can't be a witness, certain links, so on and so forth. And it's interesting in the Middle East that it's still one of those regions where in some jurisdiction in the UAE, there has been a change if the parties agree. But for example, oath remains an important part of the landscape. And so whenever witnesses are providing an oath before a tribunal in the Middle East, depending on the seat of the arbitration, and unless the parties agrees otherwise, typically you have, witness testimony starts under oath. And I think if we need to think a little bit from a philosophical perspective as to why is that the case, and that really links to the fact that there is some sense of skepticism towards witnesses. You need to have some sort of something more formal, gravitas, to make them understand that it's very serious, the testimony that they're giving, and there needs to be an oath. And in some instances, you have to swear an oath on the Bible or on the Holy Book, on the Quran, so on and so forth, just to give it that sort of a gravitas. And typically you would do that when there's an underlying doubt that you need to make sure that whatever is being said is the witness really takes this seriously. That's just the general observation. The second point, and which is interesting, you may have heard of a recent ICC Commission report, which was issued, I think last year. And the topic was about the accuracy of fact witness memory in international arbitration. In that report, the committee examined a lot of first scientific studies and research, and they all overwhelmingly concluded that scientific research demonstrate how the memory of even an honest witness may be at risk of being corrupted by the interaction that commonly take place in the preparation and presentation of that witness evidence in arbitration proceedings. Now, what they then conclude is that although this is a scientific reality, the memory of a witness is not necessarily the only reason why you would put witness evidence in international arbitration, because often witness evidence is there to tell a story, to present a face, and sort of to present more context, and so on and so forth. And so that remains an important issue, which then links back to the approach generally in civil law and certainly Middle Eastern jurisdictions, that there's a lot of primary reliance on documentary evidence. That's the preference, and then witness testimony. In terms of standardized approach, I certainly have seen in at least trying to define the rules from the beginning in the first procedural order under the section dealing with witness examination, certain tribunal would clearly say that it would not be improper for counsel to assist witnesses in preparing witness statements and so on and so forth. Now, sometimes you query whether this is a wise thing to put or not when looking at the laws of the seat. I won't get into that discussion. But maybe before I conclude, because we can talk a lot about this topic, is I also invite sometimes sort of a reflection on whether you really need to make sure that witness statements are so polished, and then I think counsel sometimes overdo it and they forget that basically you need to let the witness speak in his or her own voice, and that sometimes enhances really the credibility of their case. You don't need to have standardized witness statements that look all exactly the same and perfect before a tribunal, as long as, of course, the witness statements are not are clear and the message is clear, then that's enough. So I think sometimes overdoing it to try to sort of increase that involvement in terms of polish and sort of standardized forms may not always help a party in its case. At the end, it boils down to the reliability of the witness himself or herself and how they present before the tribunal, how credible they are. But I've seen oftentimes, particularly in the Middle East, witnesses who are relatively unsophisticated in the sense that in terms of drafting, and they excellent engineers or etc., but not necessarily masters of the word. And you can see that great gulf and divide when they're being cross-examined or at the hearing between the tone of their witness statements and then the story or the ability to convey that story. So these are things that really counsel should be very much alive to at the beginning when they're interviewing witnesses, to consider whether they can be sort of suitable witnesses or not in an arbitration. And the last one to conclude is, of course, here there is another issue, and I think going back to the culture, And I think you mentioned that the tradition between lawyers trained in different jurisdictions may be subject to different bar rules and ethical rules. And that's a struggle because sometimes you approach it from one perspective, you would assume that it's a fair level playing game, and then the counsel for the other side will and should act in the same manner, but sometimes you get surprises. And unfortunately, this is when you have an imbalance in party representation, which makes it very difficult. And it's up to the tribunal to try to find that sort of early engagement to try to set the ground rules from the get-go.
Thank you. I think it was particularly interesting that the standardized preparation that lawyers put a lot of effort in to prepare the witness statements, etc., might have adversary effect on the credibility or reliance of a witness eventually. I want to hear from Sammy on this further.
Well, in Korea, regarding the witness prep, there's no explicit rule governing the witness preparation unless we are advising or guiding the witness to commit perjury or to give false statement. So it is common practice to do some mock exercise before the cross-examination, just to give them an idea how the proceeding will be in the actual hearing. And the witnesses would also expect the counsels to give some guidance before the hearing, but I guess one difference from the Spanish practice approach, what Omar shared, is it is common practice in Korea that once the witness starts testifying at the hearing, he or she should not talk to or discuss with the counsel unless the witness is released from the stand. So I guess that's the practice in Korea. And regarding the issue about the witness testimony, I guess Korea court practice tends to rely on documentary evidence and would give little weight on the witnesses and only have limited cross-examination. And I think the reason is because they think the witnesses are just telling their version of the story instead of being an objective observer. But in international arbitration based in Korea, I guess it's they're relying more on witness evidence. And I think it's mostly because of how the Korean companies work. So traditionally, many Korean companies tend to rely more on oral communication, and they would not keep a detailed record of what's being discussed in the meetings or what have been instructed by the seniors. And some companies would even encourage the employees to dispose of the important documents to avoid some serious investigations. So when Korean companies are involved in international disputes with foreign companies, they didn't have sufficient documentary evidence to support their case or to rebut the other side's argument. So they had no choice but to rely on the witness testimony to prove that the party's intention was beyond what appears in the four corners of the document. So I guess there's some like this cultural background to what Korean practice is.
All right. Jay, what are your experiences in this regard? I'm also curious if the Philippines also would have similar business practice as to not putting a lot of things in document.
Right. Well, the Philippines, as I said, is a mix. In the preparation of witness statements, it is not unusual for lawyers to assist in the preparation of witness statements. And this is something that, I mean, very similar to what was described earlier by one of the panelists. There's well, first the lawyer will talk to the witness, the lawyer is going to take down notes, and then the lawyer will prepare the first draft of the witness statement based on the notes during that meeting with the witness. After that, you're going to have a meeting with the witness and then talk about the content of the initial draft. If there are any changes, then that's going to be implemented. And then after that, there's going to be the notarization of the witness statement. if it is required. Otherwise, it's not required if it's an international arbitration, and then that will be submitted to the proceedings. Now, during the preparation for the actual hearing, it is also not unusual for the lawyer to conduct mock cross-examination, or mock direct examinations as well, or mock redirect examinations with the witness, just to make sure that the witness, is really prepared and knows what to say during the hearing, and also to know what to expect. I had an experience where I was examining one of my witnesses in one of our cases, and the person actually cried because they were like, I didn't know it's going to be this much stressful. And she started crying. And of course, had that happened in the actual proceeding, and the person just kind of, cried during the entire proceeding and not be able to say anything anymore, that would have been a disaster in my case. So it would be good, at least from my part during that time, I was happy that we were able to show this witness how it's like, at least the worst case scenario that can happen during an arbitration.
That's a nice episode to hear, like how drastic it could be. I'm very wary of the time limit we have. We have two very important questions left to hear from our panelists, one of which is of my particular interest, approaches of the arbitrators. But it seems like we will have to arrange another webinar with the same panelists to hear about it. I know our panelists prepared a lot to give a talk on this, but sorry, but allow me to skip to the very last one, and I will give 1 minute to each panelist to just wrap it up and give us the highlight of what the divide between common law and civil law you see in the matters of substantive law. I know it's a lot that I'm asking, but we'll give a try. So 1 minute or 1 minute, 30 seconds. I will start with Ziad on this.
Thank you. Okay, I'll do my best in 1 minute because
Sorry.
This is a very big area, but I'll focus specifically on good faith, because I think if I want to pick an example where there's a big divergence between common law and civil law and the approach, it's really good faith. And then focus on the Middle East. I would say that good faith really is a sacrosanct principle in Middle Eastern legislation. It's really sort of all over the codes in the region. And it has wide-ranging applications, and it's important for parties and obviously tribunals to understand the implication of the obligation of good faith, because from that not only translates issues such as the execution of the contract in good faith, but also their interpretation and also certain notions of implied term. But most importantly, 2-3 points that are important to keep in mind in the Middle East is first, what derived from the principle of good faith is first a notion which we call the preclusion of contradiction, and that is something that is prevalent in the Middle East, that it sort of translates into a duty of loyalty and coherence. You can't contradict yourself. It's similar to sort of estoppel, but it finds grounding in the Middle East in various jurisdictions, and the root of that goes back to the rules in the Ottoman Civil Code, the Majalla. The second point, which is important, also derived from good faith, is the notion of abuse of rights in the Middle East. Those who are contracting in the Middle East, whether going from Qatar to the UAE to Oman to the broader region, there are very important provisions on the unlawful exercise of a right, and that a contractual right in certain circumstances can be deemed to be unlawful if, for example, one of the cases, the benefit that is derived from exercising that right is vastly disproportionate to the damage that can be caused from exercising that right. And of course, these types of provisions, which are in some instances just drawn also from certain sort of Sharia principles, are not very common in common law jurisdictions, where you sort of have your contract and there are very limited sort of applications for notions of unlawful exercise of a contractual right. The third, that's maybe the final point that I would say a big divide is in construction contracts, the treatment of liquidated damages provisions. I think parties should know that in the Middle East specifically, that a judge, upon application of a party, can adjust the pre-agreed liquidated damages in the contract, which is something, again, that is not common in common law, and then it can be in many jurisdictions, it can be adjusted downward if there is no loss or there's a disproportion between the actual loss and the amount in the liquidated damages. And in other jurisdictions, it can be adjusted upwards as well, not just downward, if the loss far exceeds the amount that is specified in the contract, which is, again, a very different approach that specifically the Middle East can take in relation to the treatment of an issue such as liquidated damages in common law systems. That's it. I think, I hope I've not exceeded my minute.
All right, thank you. Jay, you're next. And
I'm very
then
mindful of the
Semi and
time.
Omar.
I'm very mindful of the time, so I'm going to keep it short. When I was preparing for my exam in the UK for my qualification, I was looking at the concept of trust. And when I looked at the concept of trust, I was like, where did that come from? Because I never learned that in from a civil law background. But in the Philippines, it being a mix of civil law and common law, we also have very limited provisions of trust in our civil code. So I guess that's just one thing that I can share to everyone. When you think about trust, it's mostly common law. It's common law based, not much in civil law, but there are certain countries that have trust. And if they have trust in their legal system, the application is very limited.
Thank you. Now it's Semi.
I tried to think about some difference between civil law and common law, but I couldn't think of any. And I would just share one thing, which is kind of special in Korean law. You might face this issue when you're arbitrating under Korean law. It always comes up, and there's no like the correct answer to this question yet. That is about the delayed interest. So there, usually under Korean law, the normal interest rate would be 5% or 6%, but under Korean law, there's a higher annual interest rate of 15%, which applies under a special act. And from the day after the defendant receives the claimant's plaintiff. So it usually only applies to court litigation, but in Korea, in arbitration proceedings based in Korea, counsels would argue that that should also be applied to arbitration. And there's also disputed a bit, like not a big dispute, but a dispute over this issue. And some tribunals would say, I would apply that higher rate. And some tribunals would say that should only be applied to court litigation. And like the purpose of that is to encourage the speedy, amicable resolution of disputes, which might be difficult to apply in international arbitration. So if you're arbitrating based in Korea, just be mindful that you might face this issue.
That's a very good point. Thank you, Semi. And Omar, the
Yeah,
last one
thanks.
to close the grand topic.
Thanks a lot. Yes, thanks, Ingrid. I do like the good faith argument that Ziad was mentioning, indeed. But I would say that a basic principle of the common law of the common law of contract is that the parties to a contract are free to determine for themselves what primary obligations they will accept. This is one of the basic principles, and this is, I would say, a higher level of freedom to contract that we have in civil law jurisdictions, where precisely because we have good faith principle, we will have now a lower freedom of contract in fact. So what we see, and I see myself in my experience, is that even when the parties have determined by themselves whatever obligations in a contract subject to English law, and from our perspective, that would be too much or that would be unenforceable. According to English law, that would be enforceable and totally fine, because they don't have the good faith principle, if you like, a concept that will predetermine what the parties can up to where the parties can go. So I think this is one of the the issues that really comes a lot when we have English law in the context. Yeah.
Thank you. I feel like we owe it to the panelists for not giving so much time to share their expert opinions on all these issues, of course, including expert testimony and approaches of arbitrators. So Kyunghwa and I are planning to have a short report on our webinar today in the following days or weeks. So perhaps those missed issues can be covered by our short report. Hopefully the audience can also check out the report later on and yes, catch up with the issue missed on our webinar today. Thank you all for staying over the hour. And thank you for the panelists for giving a wonderful talk. Thank you very much. Thank you, KCAB. Thank you, Kyunghwa, very much for the organization and for hosting. We'll say goodbye now, unless there's any other comment or last word. So
you.
yes. Bye to all. Thank you, everyone.
Thank you, everyone.
Thank you, everyone.
Thank you.
Bye.
Bye.